me just now, it was the second best introduction in my life. You will ask me which was the best introduction. Best introduction was when there was nobody to introduce and I had to introduce myself. But it was a
Thank you,
wonderful
sir.
job. Forget that. But I am really honored and it's really a pleasure to listen to Uday Varunjikar, who's our president of Consumer Court Bar Association, also a very, very active and member who has given a great contribution to the Bar Council of Maharashtra. He is also vice president of Bar Council of India. And I think he has put up every program that he does has put to national, really on the national level and at now international level. Thank you very much. उदयजी मराठी अशा आमची मायबोली अमृतासी पैजा जिंके आणि म्हणून मराठीत सुरुवात करतोय. आज खरं सांगायचं तर मला एक थोडासा एक चुटकुला आठवला देन विल गो टू आवर टॉपिक. अमेरिकेमध्ये एक सायंटिस्ट वन सायंटिस्ट इन अमेरिका used to give a lecture on nuclear physics and he had 25 lectures 25 लेक्चर होती आणि त्यावेळेला त्याचा ड्रायव्हर त्याच्या बरोबर असायचा. आता 24 लेक्चर झाल्यावर सायंटिस्ट थोडासा आजारी पडला आणि he felt sick and he could not deliver the lecture. So the driver was smart like me. He said, sir, I can speak well and तुमचं सगळं भाषण माझं जवळजवळ पाठ झालंय, recited, I can deliver. And he really give me a suit boot and you wear driver's clothes. So he wore the driver's clothes and sat and relaxed. He delivered lecture really good because he was a good speaker. But at the end of the lecture, there was a problem. The problem was question answers. No, he was not technical. He did not know anything. So he said, do one thing, write all your answers. All your questions and I will give the answers. Then those questions were given in writing. He said, these questions are so simple that my driver will really answer this and he handed it over. Uday Varunjikar, Uday Wavikar mix-up हा होतच असतो. पण ते एक गोष्ट लक्षात ठेवा, the real scientist is Uday Varunjikar. He is the creator of this function and I'm really thankful to him for such an innovative contribution for training to entire judges, the persons who want to become judges, the person who wants to become president of Consumer Forum, persons who want to become members of the Consumer Forum. And this kind of interaction, this kind of guidance was a must because this is called the awakening and it's a unique project of Bar Association of Maharashtra. The credit really goes to the entire team and I am really thankful to them for that. Now let us begin with the language. Somebody wrote in English. I want to recognize one person here. Justice Bangali is of course there, who is my guiding force, and I requested him. It's our honor because Justice Bangali was a trendsetter as far as execution is concerned. And they say the fruit of every decree lies in execution. There are nearly 7 builders who were sent to jail for 3 years rigorous imprisonment for non-complying the order and big builders, which will set an example to the people with proper procedure. And he used to really curtail the delays in the execution. So I think there are a lot of things. Therefore, I said justice delayed would be justice denied. But at the same time, there's another person who was a very senior advocate from Erode in Tamil Nadu. And he is one of the founders of JCI, Justice International. And he was the vice president international for many years. And he was also our godfather. On our program, he said, I would like to join the program, and he's present here. Thank you, sir. For you are being present here because he is one of the great guiding force, even to the son-in-law of the Law Commission, then Nachappan, and now who's the Ravi Shankar, who is now handling the JCI affairs. Thank you, sir, for being present. Now, coming back to our topic today, I would only say, as far as languages are concerned, मराठीत बोलायला माझी मुळीच हरकत नाही. काही तुम्हाला वाटलं तर मी मराठीत चांगलं बोलू शकतो कारण मराठीचंच माझं शिक्षण झालं आहे. परंतु ज्या वेळेला भाषेचा प्रश्न येतो त्यावेळेला मी नेहमी म्हणतो, मेरी भाषा को ना देखो, मेरी भावना को देखो, मेरी भाषा को ना देखो, मेरी भावना को देखो, मेरे लिफाफे को ना देखो, उसके मजनून को देखो. हृदयाची भाषा ही फार महत्वाची असते. लेट अस शेअर इन सच अ वे that we talk the language of the heart. And that is most important. मराठीचं ज्ञान हे महाराष्ट्र कंझ्युमर राज्य आयोग ॲज वेल ॲज फोरम्सला फार इसेन्शियल आहे. कमिशनला फोरमच्या कमिशनला आणि मराठीतच ऑर्डर बहुतेक ठिकाणी केल्या जातात. त्यामुळे मराठीचं ज्ञान हे खूप महत्वाचं आहे आणि ते आपल्याला मिळवलंच पाहिजे. पु ल देशपांडेंनी म्हटलं असं होतं की इंग्रजी ही आपल्या घराची खिडकी असावी, आपलं घर नसावं. लेट अस गो बॅक टू दी टॉपिक विच इज व्हेरी व्हेरी व्हायटल. कारण आज काय झालंय, बरचसा गोंधळ वकील मंडळीमध्ये आहे. बाहेरच्या वकील मंडळीमध्ये आहे. नवीन कायदा आल्यानंतर देर इज सेक्शन 71 आणि सेक्शन 72 दोन्हीचा जो चेंजेस झालेला आहे त्या कायद्यामध्ये, त्याच्यामध्ये लोकांना 2-3 तऱ्हेचे गोंधळ आहे. पहिला आपण एक गोंधळ सेट करूया. लोकांना काय वाटतं, कारण नॅशनल कमिशननी जस्टिस अगरवालनी ऑर्डर दिली होती की जुन्या ज्या केसेस आहेत त्या जुन्या केसेस त्या कमिशनला राहतील. त्या ज्या वेळेला ज्युरिडिक्शन पिक्युनरी चेंज झालं, ते पिक्युनरी ज्युरिडिक्शन जेव्हा चेंज झालं तर अशी परिस्थिती आली की सगळे मॅटर्स नॅशनल कमिशनचे काही स्टेटला जातील, स्टेटचे मॅटर जसं हायकोर्टात झालं सिटी सिव्हिलला गेले, स्टेटचे मॅटर असतील ते फोरमला जातील. तेव्हा त्यांनी स्पेशल त्यामध्ये सेक्शन ऍड केला कायदा बनवताना. सेक्शन 107 जनरल क्लॉजेस 6 प्रमाणे त्यांनी सांगितलं की ओल्ड मॅटर्स विल बी अंडर ओल्ड मॅटर्स. काही अपीलच्या प्रोव्हिजनसाठी डिपॉझिट्स वगैरे ऑल्सो जुन्या मॅटर प्रमाणे असेल. तेव्हा प्रश्न असा आला की एक्झिक्युशन जे फाईल करायचं आहे, व्हॉट एव्हर वी हॅव टू फाईल दिस एक्झिक्युशन, इज इट अंडर द न्यू ऍक्ट or is it under the old act? National Commission in the recent judgment, which we will give it to you the details of the recent judgment. Can I get the share link, Shabnam? All right, I will give you the National Commission. नॅशनल कमिशन मला वाटतं म्हणून मी ऑडिओ व्हिज्युअल घेतलं त्यावेळेला आपल्याला क्लिअर होईल की यू कॅन रीड ऑल्सो बिकॉज द इफेक्ट ऑफ ऑडिओ व्हिज्युअल इज मच बेटर than this thing. The judgment very clear is there. The guidelines are very clear now that the execution proceedings being the separate proceedings. Now this is a judgment of Honorable National Commission of 2022, April 2022. In the case of Amit Agarwal, and this is very clear, which says that the which says very. This is also the judgment delivered by Justice Honorable retired Supreme Court Justice and President of the National Commission, Justice Agarwal, Ms. R.K. Agarwal, which says very clearly that the execution proceedings are separate and independent proceedings for execution of decree, and therefore it has to be filed under the act which has been now prevalent at the time of filing of the execution proceeding, which means now we have to file all the execution application under section 71 and 72 of the new act and not under section 25 and 27 of old act. So let us be at rest, because there's the first question to many advocates is because of this confusion provision whether the execution we have to go by old act or not. There is the new amendment of the acts are much more advantageous to the old act, and we will deal with it, especially for the attachment proceeding. Order addition of order 21 is a fantastic provision. Of course, there are certain limitations. We will also discuss that as a guiding factor. But one thing I would like to appeal every person who is desirous of becoming member of the forum or the president of the forum or state commission, for that matter, the member or the president, whoever is desirous, should definitely keep in mind that the ultimate thing in any law is execution. And if you are delaying the execution, it will be like justice delayed, and the decree would become really meaningless. And that has happened in some cases because of infrastructure of the consumer court, because of the various problems, long dates given in the execution. There are some executions where the decree came in 4 years, but the execution took 6 years or 7 years. So that should not be there. Therefore, my earnest request is, if you all, and I wish you all the best, become the president of the members. Today, Justice Savde is giving top priority. Justice Bangali is to give top priority. The executions are listed on the top of the board. And please continue such a good practice. Give as long as shorter dates, so that the person who gets a decree after fighting nearly average 3 to 4 years get the advantages and fruits of that decree. So that would be our guiding principle. 90 days consumer for the act says, but it took because of various problems, it always takes time. So therefore, let us not let us put the execution as the top priority. Now, what are the ways that once you get the order in the favor of a decree holder, what are the ways that the execution can be filed before the consumer fora? Those who are regular in consumer forums and now member, etc., know. But even then, the new act is very, very important, and the changes in the new act are really important. There is execution of application, execution of any order passed by the Honorable District, State, and National Commission can be done under the following sections of the Consumer Protection Act: Section 71 and Section 72. Now, Section 71 basically deals with the attachment of properties. It also deals with the payment that is to be recovered, and it also deals with various aspects of Order 21. And under the Order 21, under the Section 71 of New Consumer Protection Act, every order made by the district commission, state commission, or national commission shall be enforced by the same manner as if it were a decree made by the court in the suit before it, and provisions of Order 21 of the first schedule of the Code of Civil Procedure 1908 shall be as may be applicable, subject to modification, that every inference therein to be decree shall be construed as a reference to the order made under this act. This is very important because insertion of Order 21 has changed the entire game. Initially, we had to go ask for the attachment of the properties for recovery of consumer dues from the collector, and that is to take a lot of delay. The procedure of Order 21 has given vast powers to consumer court, but again there is a confusion here. Confusion is people, many of the, even I, with all due respect, judges also, who are come from civil background, try to reopen the case under the Order 21. The Order 21 is only applicable to the extent of the decree of the consumer court and not beyond that. So we'll have to restrict to the heart of the Consumer Act, that is the deficiency of service and unfair trade practices and non-compliance of the order. Now, various things are really achievable, and I would touch upon the latest thing which are really helping to the consumers under Order 21. The decree holder has to make, now under 71, the execution proceeding, decree holder has to make an application to the commission which passed the order. So the jurisdiction is only to the forum, state commission where or national commission wherever the order is passed. This is under the Order 21 Rule 10. The decree holder is required to give full disclosure of the property which is to be attached to satisfy the decree. Order 21 Rule 12 and 13. And remember, a lot of people talk of only immovable properties. But here, even the movable properties can be attached if necessary. After receiving an application for execution of order, the commission verifies whether the application has complied all the requirements given under Rule 11 to 14. Only upon all the compliances made by the applicant, the commission admits the said execution, that is Order 21 Rule 17. These are only with reference to Consumer Protection Act, because Order 21 is a very huge order, confusing order, and therefore I am only restricting myself to the required execution under the Section 71 for basically attachment of properties and recovery of the dues. After admitting the said application, the commission issue notices of the judgment debtor as to why the decree should not be executed against him. That is Order 21 Rule 22. I am just revising quickly. Most of you must be knowing this. In case the applicant is unaware of property held by the judgment debtor, as the applicant can make application under Order 21 Rule 41, which gives a power to the commission to orally examine as to whether any or what debts are owing to the judgment debtor, and whether the judgment debtor has any and not whatever property means of satisfying the decree. And the court may make any order for the attendance of the examination of such judgment debtor or officer or other person, and for production of any books and documents. Now, the only problem here is practical problem. I have practiced 26 years in consumer court infrastructure. We are really facing, and we are all together fighting for it. The practical problem is there are no bailiffs available to us, and therefore most of the times, even Justice Savde or even otherwise, advocates are appointed now as the commissioner. Still, they are doing very good job. Registrars of the court also can go and perform, or the staff of the court whose legal department is also requested for assisting the advocates who are of the commissioner. But I hope the infrastructure will increase to an extent with the new amendment that the bailiffs provisions will be also applicable. New bailiffs will be appointed. This is one of the suggestions. Of course, we will fight it out, and we'll have to really ask for it. But today also it is very effective. Even advocates are really going attaching. I have done in 2-3 cases recently where the property of the builder, where the flat, which was itself a decretal flat, was attached and it was given to the consumer. So the fruits of the entire judgment was to get him the possession of the flat, and that was delivered to him. Now, as far as the, in case there is a after getting all the details of the properties of the judgment debtor, the commission proceeds with the attachment of the movable as well as immovable property. People do not concentrate on immovable property. Let me tell you my experience as far as immovable properties are concerned. One of the decree debtor who was avoiding continuously, he had a flat in Pedder Road, and I will not name it, but it is a case which is our case only, where we have attached his TV, fridge, and everything was brought down by the collector that time under section 25. And once that was done, his wife was really annoyed, and everybody, he was annoyed because entire building was looking at what is happening, and therefore he came and really complied the order. Similarly, the flat where the third parties in the new act empowers now, where the third party interests are created also can be made parties as an obstructionist to the execution, and we can thereafter get the decree. In fact, Bengali Sahib has issued certain attachment of the flats to tell the third party who has illegally occupied the flat as an obstructionist of the execution to bring the keys and submit. And that effect was, that was again in one of our cases and many cases, the effect was builder really settled the matter because there was a pressure of the third party on the builder. So execution in consumer court is now powerful under the section because of the adding of the order 21 specific. The court has been given specific powers to direct the bailiff to attach the properties of the judgment debtor, and the property attached is kept in the custody of either the bailiff or the commission. In those cases where the third party interests were created, the keys were submitted to the registrar, and then therefore the builder also was in a hurry because there was a pressure of the person who was owning the flat. So who was second, of course, second flat holder was given the possession. So consumer now difficulties and limitations, as I told you, consumer courts do not have bailiffs today, and therefore the consumer courts can appoint any fit person or a bailiff to attach the properties. Here now the commissions are appointed, advocates are appointed as a commissioner, and we are moving further. In case the judgment debtor fails to satisfy the order, then the commission have powers to sell, auction. This is again an important power. To sell, auction, and attach properties under the order 21 rule 64, which is as under. Any court executing the decree may order that any property attached by it and liable to sell or such position thereof as may be necessary to satisfy decree shall be sold, and that the proceeds of such sale or a sufficient portion thereof shall be paid to the party entitled under the decree to receive the same. This is something which is really clear now, that you can attach the properties, even the personal properties of the builder in case of builder cases or other decree debtors, and then they can be auctioned. Monies can be recovered, and after the auction, the monies whichever comes are paid to the decree holders. That means that then it can directly satisfy the monetary aspect. It can even satisfy the compensatory aspects and interest inclusive of everything. Next slide. Okay. Now let us, there is some internet slightly slower, but don't worry. Where the order is for handing over the possession of immovable property, the judgment debtor then order 21 rule 35 gives a power to the courts to take forceful possession. Again, I have given example of Justice Bangale, but there are many other such judgment now. Justice Tavde has also passed, where the possession has been taken in the custody said immovable property after giving sufficient opportunity to the person who is a possession and hand over the possession to the judgment holder. Now there are both are coming here. The third party who is holding the flat also comes here. Not only the third party, I'll come to that power, but the builder. Suppose the flat that is in question, which was supposed to be delivered to you, is in possession of the builder. After getting a degree of possession, my own case of Shashikant Shetty recently, one of the advocates was appointed as a commissioner along with the staff, and they sealed the flat, and later the possession of the flat was given to it. So this is how this has become really fruitful. Otherwise, it used to take a lot of time to go to collector. Then collector will implement. If he doesn't implement, we file a writ of mandamus, etc., etc. I don't want to go because that is no more there. The old act is over. The new act has come in. You given sufficient power under Order 21, and that's a great boon to the Consumer Act. Of course, the implementation part still has to be improved. Now, let us go further. Apart from taking the forceful possession of the properties, we have been also empowered that property of the judgment debtor is already attached by any other court. This is again unique provision. Now, suppose there is a High Court has taken over the property under some other this thing by some decree debtor it is attached, or any other court has taken that, then the consumer court under the Order 21 Rule 52 gives powers to commission as follows: where the property to be attached is in the custody of any court or public officer, the attached collector also, that includes collector also, the attachment shall be made by a notice to such court or officer requesting that such property and any interest or dividend becoming payable thereon may be held subject to further orders of the court from which the notice is issued. So they can take the fruits of decree even if it is held by the other court or attached by the other court, and the consumer courts have every powers to inform, and the other courts will consider if that is so position. So you don't have to worry, because if the builder is High Court has already attached the property, and what do I do? I've got a decree in consumer court. There that will also go to the said custodian of the property as far as the execution under Section 21 is concerned. Now let us go to another feature which is very, very vital. Today, the burning issue is conveyance. Team conveyance, I would not comment, but I would say the new things have come within 1 month. You take conveyance, etc., etc. Consumer courts are not giving deemed conveyance, but are giving conveyance under the civil decree, and therefore order now. Suppose the builder does not cooperate to give the conveyance, he doesn't come, or a landlord doesn't come. That was the problem, because the consumer court is to give an order that all the parties shall execute the conveyance. Now the registrar would say all parties should give the conveyance. Where are the powers? Under deemed conveyance, registrar of cooperative signs the conveyance deed. I have no power. He says you bring all the parties, and that was the problem. Supreme Court in the case of Kamlesh Agarwal solved this issue, and this is very interesting because this gives a new power, like a more than deemed conveyance in an execution, which is much faster and much easier. Where a civil decree and non-compliances of the parties, if they are not coming forward, they are acting as an obstructionist. Registrar can sign the conveyance deed of the consumer court. I will tell you, this has become very effective as far as execution of conveyance orders are concerned. And this is a new thing. Most of the people may not know this provision has come because of the judgment of Kamlesh Agarwal versus Narayan Singh Dabbas, having a civil appeal number 224 and 225 of 2015. The order is though directed the registrar of the district commission to sign and execute the conveyance deed on behalf of the builder developer where the opposite parties were non-cooperating and obstructing. Most of the time, if I find builders are obstructing, if builders are not, or they are not available, if builders are not obstructing, then the landlords are obstructing. So therefore, because the property is in the name of landlord, therefore, the consumer courts have now powers to appoint registrar to sign such a conveyance deed in place of those parties. Registrar will sign, and again, registrar doesn't have to go even to execute such conveyance deeds before the appropriate authority. As long as he sends a letter, his signature is recognized, because now most of the mutation entry registrars also are aware that the registrar is allowed to sign under the deem or now under the Consumer Protection Act, where you get a clear civil decree. So this is a big boon which has come in the Order 21 Rule 32, which has been happening. I have done several cases, but apart from me, Justice Gavde is also really passing a lot of order, Honorable Justice Gavde, and Justice Tavde has been passing a lot of orders, and it is a big boon to consumers where they do not get cover any, for that matter, landlord is not available or builders are not available. And this, I think, is going to create a sea change as a game changer in the new execution powers of Consumer Act. Section 72 is another penal section under CRPC. Now, the person who pays this also is a lot of deterrent, where I have said a lot of builders have gone to the jail for non-compliance, even to the extent of 3 years. But there are still some confusion, and we will solve those confusions practically as well as legally. Whoever fails to comply with any order made by, there is a twofold remedy in Consumer Court, and that is the beauty of the Consumer Court, because then the Consumer Act has got teeth to bite. If you see comparative laws, including RERA, there are no such tit to bite and there is no penal provision. I am not criticizing, but the effectivity comes only when there is a deterrent and penal provisions. So, because the decree in RERA also is not executable by the court. Here, the Consumer Court, the president of the Consumer Court becomes judicial magistrate, and we'll deal with that. He's got the powers of judicial magistrate. Whoever falls to comply with any order made by district commission or the state commission or the national commission, as the case may be, shall be punishable with imprisonment of term, which shall not be less than 1 month, but which may extend to 3 years, or with the fine, or which shall not be less than 25,000. Now, this is a change. Originally, there was only 10,000 rupees, and builders used to laugh. Or the non-compliance, I'm talking builder non-compliance. The decree daters used to really have a fun on it. 10,000 rupees, de do, khatam karo. There's no mens rea, or there's no this thing. Such orders were also passed. But now it is, the fine is 3 years imprisonment. Now, another question here, we'll pause here. The CRPC says that if there's a trial, if there is a 3 years imprisonment, trials will have to be conducted in full. But in the Consumer Court, there's a shortcut to these trials also, and therefore only related portion of the orders, because the decree dater cannot go beyond the decree. And even the judges, especially all of you who are going to become, should not allow him to make irrelevant process and irrelevant statements, reopening the cases. That has nothing to do. The order has been passed, confirmed, reached finality. So while doing this procedure, very important is the entire heart of the entire 27 at that time and now 72 is that the decree holder has to really get a justice in terms of penal provisions, which are only restricted to non-compliance of consumer order and the reasons for non-compliance of the consumer order. So whoever fails to comply with any order made by district commission, state commission, national commission, as the case may be, shall be punishable with imprisonment of term which shall not be less than 1 month, but which may be extended to 3 years, or fine which shall not be less than 25,000 rupees, but which may be extended to 1 lakh rupees or both. So this is a change in the new act totally. Again, notwithstanding anything contained in the Code of Criminal Procedures 1973, the district commission or the state commission or the national commission, as the case may be, shall, this is very important, have a power of judicial magistrate of first class. Look at the powers. First class judicial magistrate can even call up chief minister of the state or a prime minister of the country before him. These powers are now given to the Consumer Court, and of course now the unfair advertisements, misleading advertisements have come. Brand ambassadors are also responsible for it, for not doing the due diligence. Maybe I see that tomorrow the brand ambassadors, like actors who are coming, I should not name them, you know better, will be also called in the trial. So therefore, the first class magistrate powers are given. Now the question there technical was that these powers were to be confirmed by the state government, the High Court of each state. Now that has been removed. It is uniform at the national level. They are deemed to have such powers of judicial magistrate first class for the trial offences under subsection 1 and conferment of such powers of district commission or state commission or the national commission, as the case may, shall be deemed to be a judicial magistrate first class for the purpose of Code of Criminal Procedure. In other acts, sometimes there was a situation where you have to go for execution to civil court or criminal courts. I will not, of course, you know the act, including RERA. So what happens is at that time, then there is no teeth to bite. Here, the Consumer Courts itself will run the trial, criminal trial, complete, and send the builder to the jail or attaches movable and immovable properties, recover the dues is a big power and big chunk, big change which is given, which will be deterrent for non-compliance of the order. Save as otherwise provided, the offences under subsection 1 shall be tried summarily by the district commission or state commission or the national commission as a case. This is the heart. Summary trials are nothing but avoiding lot of formalities in the trials, and therefore a trial has to do in a way. I will now take you to the entire procedure in a very short time. The commission is under section 72. This is a procedure under 72 of New Consumer Act 2019. The commission is bound to execute the decree and take the penal action. Penal action. The respondents, by following the procedure under section 262, read with chapter 2 and section 251 of the Code of Criminal Procedure Code in accordance with the law. Now, in accordance with the law means in accordance with the execution proceedings of Consumer Code. I explained to you that even if there is a 3 years imprisonment, full trial is not required. Only these summary trial procedures are required. The decree holder has to make an application to the commission, which passed the order naturally, whichever is the commission. Then after receiving the application under section 72, the commission issues summons to the accused. Now again, many of the times people are issuing compliance notices. The compliance notices will go under section 71. When we are under CRPC, summons will have to be issued, which is of course all due respects to all of you. But this has to be remembered, because many a times we find in consumer court notices are issued even in 72. Summons of the accused respondent through the concerned police station. This is again important. In the case of accused, the respondent files to appear before the Honorable Commission. The Commission issues bailable warrant to compel the presence of the accused and respondent. Question comes is, many a times we find police station taking the amount of the bail. Now that is allowed, provided, of course, in the order, such bail amount is normally mentioned. So you being the judge, tomorrow's future judges and members, you have to remember, whenever you issue a non-bailable warrant, you must put the amount of bail also, whatever is the bailable amount, or even the securities if they are mentioned. If accused respondent fails to appear even after serving the bailable warrant, when the commission issues non-bailable warrant, then there will be straight away the police station ought to arrest the person and put before the accused respondent has to make a bail application. The bail is granted to the accused. If the bail is granted to the accused, he is bound to execute personal bond and surety bond of any sum as may be fixed by the commission. Any sum is very important. The accused can either give a cash surety or a solvent surety directed by Honorable Commission. In case accused being solvent surety, then the accused can be released by executing personal bond of and the Honorable Commission gives specific time to execute the security bond before the next date of hearing. There is some confusion on securities, that in case the security gives the bond, the amount of the security is also mentioned in a security bond to the extent of decree. What happens is, if the decree debtor does not comply, it is not that the security is bound to comply his order. That confusion will have to remove from our mind. Of course, it gives a lot of deterrent when you press the security person giving security that he has to perform as per the solvent securities, and sometimes the properties can be attached to recover the said amount. Now, section 251. Once the bail procedure is completed, then the court can start trial under the following procedure. Section 251 under the chapter 20 of CRPC, and this reads as under: substance of the accusation to be stated when the summons case the accused appears or is brought before the magistrate, that is of course the president of the commission, and particulars of the offences which is accused shall be stated to him. He shall be asked whether he pleads guilty or he pleads non-guilty, or has defense to make, but shall not be necessary to frame a formal charge. There is no necessity of framing a formal charge. Next. Therefore, this has to be very clearly understood. If the accused pleads guilty, then he can be convicted and punished in terms of section 72 of Consumer Protection Act 2019, if the accused pleads non-guilty, please correct this, this will be pleads non-guilty, then the commission has to record the evidence under section 262 of CRPC, which states as under, in every case tried summarily, in every case tried summarily in which the accused does not plead guilty, the magistrate shall record the substance of the evidence, not the entire evidence, and the judgment containing a brief statement of the reasons for the finding. Again, very innovative fact is there. Let us look at next slide. If the accused does not plead guilty or claims he has a defense to make, then the district forum, state commission, or a national commission, as the case may be, shall record the substance of such evidence as may be produced by the complainant. The complainant can also rest his substantive evidence on the basis of the order passed, because that has reached finality. The evidence may be oral, documentary. In his discretion, the complainant may seek to rely solely upon the order passed by the district forum, state commission, national commission, as the case may be, because in a verification statement also the complainant can rely upon the judgment that has been passed, as the case may be, and in such case the aforesaid order would constitute an evidence produced by the complainant in support of his case. He doesn't have to file a separate affidavit. So therefore, the examination, at the most, cross-examination by the other side would be on the substantive evidence and not on any kind of affidavit or any kind of statements in the court. Of course, the verification statement has to be done by the judge, here also by the president, and that verification statement would contain the substantive evidence of the order for non-compliance. If the oral evidence or the evidence of the affidavit is given by the complainant, the accused would be entitled to cross-examination of the dependent witness, since the evidence as defined under section 3 read with section 138, 139 of the Evidence Act compromises not only the examination in chief, but also cross-examination and re-examination, if any, permitted by the court. Consumer court has shortcuts, but it is also natural justice. At the same time, unless the court permits, when the order has reached finality, court may not permit you to do the re-examination unless there is something which is beyond the decree, beyond the evidence, beyond everything. And evidence in the criminal trial without an opportunity to the opposite party to cross-examine the witness will not constitute legally admissible evidence. This also is says we'll have to remember. Therefore, the procedure as decided by National Commission detail has to be followed in these cases also. The cross-examination of the witnesses being fundamental and of course in the indefeasible right of the accused. That right has been given under the natural justice to the accused, and National Commission says that the trial to the extent of decree has to be gone ahead and substantive evidence has to be considered. Then comes section 313 of CRPC, where the power of Honorable Commission to examine the accused is there in every inquiry or the trial. 313 statement, of course, of the trial for the purpose of enabling the accused personally to explain any circumstances appearing in the evidence against him. The court shall, after the witness of the prosecution have been examined and before he is called for his defense, question him generally on the case. Of course, this is a very vast right where the consumer courts are now considered to be impositorial and not adverse, where the judges can also go with an express vision and find out under 313 statement the real substance of the evidence. Now let us go. Therefore, after the 313 is over, after examining the accused in terms of 313 statement of the CRPC, except where such an examination is dispensed with, the district forum, state commission, or the national commission, as the case may be, is required to take such evidence as the accused may seek produce his defense. The accused, however, cannot be allowed to lead evidence which is not strictly irrelevant. A lot of irrelevant things have been coming in because with due respect, the consumer court's decrees are already passed here. We are in an execution of a decree and we are not in a trial basically. And therefore, which is not strictly irrelevant. This is very important for all of you to consider to save the time of the decree holder as well as to give the effective justice. Not strictly relevant, you should intervene and say this is not allowed. Otherwise, it goes on for dates after dates. Let us not do that. To to the proceedings initiated against him under Section 72 of Consumer Protection Act. And only such evidence can be allowed to be produced by him as would prove legal defense to the proceedings initiated against him under 72 of CP Act. So the reasons for non-compliance in the order is very important. Whether he is responsible or not responsible, sometimes he is not even responsible and wrongly bought in. Even right or wrong, the order then remains. But at that juncture, he gets such kind of defenses. And then, of course, statutory non-compliances are also included in such defenses. So let us look at this is very important, but irrelevant evidence should not be allowed under any circumstances. The accused decides to enter, it will be always open to the district forum, state commission or the national commission as the case may be, to disallow all such evidence sought to be produced by the accused. So this is again important. He cannot insist and take time and do dilatory tactics in terms of justice for the purpose of execution. Cannot go beyond the decree. That is very important. To be produced by the accused as it is found irrelevant or frivolous or aimed at prolonging the trial, thereby defeating the mandate of the Act, which envisages a summary trial of such offences. The complainant, of course, would be entitled to cross-examination of the witness of the accused, including those whose affidavits are filed by him by way of the evidence. The accused decides to enter the witness box. Accused also can be a witness to the prosecution, and he can decide to enter the witness box in terms of Section 315 of CRPC, and the complainant shall be entitled to cross-examine such accused. Those who are practicing on criminal side know very well, especially who are very experienced and senior, normally do not put additional evidence and additional witnesses, because sometimes they can turn against you. The evidence of them itself can go against you. So therefore, of course, the natural justice is provided to accused also, but not an irrelevant facts. Final order: after recording the substance of the evidence, the complainant examination of the accused, the defense evidence, if any, the district forum, state commission, and national commission, as the case may be, shall deliver a judgment which needs to contain a brief statement of reasons for the findings recorded by it. This is, of course, very important because the substance lies. There can be 3 years imprisonment, extending from 1 month to 3 years. There can be penalties from 25,000 to 1 lakh, which is again changed under 72. Now, that another very important point, whether you are for the defense or you are for the complainant. In case the commission passes final order against the accused, there is also natural justice. The accused under the Section 72 of Consumer Protection Act, the accused can file appeal under Section 73 against the final order passed under Section 72 of Higher Court, and before filing an appeal before the Higher Court, the accused has to make an application. Remember, application has to be there. Application for suspension of the sentences only till statutory period of filing of an appeal. The accused has to make application for bail in the appeal filed under Section 73, and when only proceedings of the appeal get started. So then only the proceeding of the appeal gets started. So the prior condition, he has to file a bail also under Section 73 when he goes for appeal. Even extension of the suspension of the order can be only allowed till to the extent of the period that is allowed statutorily for appeal. I think this covers most of the gamut of the both the executions of 71, 72. Be very clear in your mind that this gives a great boon to the consumers at large, gives them a lot of power, but a lot of infrastructures are required under the Consumer Protection Act for effective executions. Effective manpower is required, infrastructure is required, all those are always there. But it says, as I say, Supreme Court says that Consumer Act is a silver line to a common man. Procedures are simplified, and we as the lawyers, or we as the judges, or we as the members, you are all being the future members, let me wish you all the best. But remember, the heart of every order is the execution. If you don't do execution effectively, the decree becomes paper decree. Justice delayed is as good as justice denied, and this will be really the entire object of the Consumer Protection Act would not be served. I would say, in the words, famous words of the great poet, which Jawaharlal Nehru put in his autobiography: "Woods are lovely, dark and deep, but we have promises to keep, and miles to go before we sleep, and miles to go before we sleep." I would thank the Bar Association of Maharashtra, the entire team. I would wish you all the best for the requisite post that you got. And I think I always quote, maybe it's an repetition, but कहते हैं कि बात ही बात में विश्वास बदल जाता है, रात ही रात में इतिहास बदल जाता है, मगर तू मुसीबतों से ना घबरा। इवन कंज्यूमर के जज, वुड बी जज और मेंबर, अगर तू चाहे, अगर हमारे बार एसोसिएशन जैसा गाइडेंस वरुण जी के कोऑर्डिनेशन से और सबसे मिलेगा, तो मेरे ख्याल से अगर आप चाहो तो धरती तो क्या आकाश बदल सकते हो। थैंक यू वेरी मच, and I'm greatly obliged by the Bar Association of the Maharashtra to give me this opportunity.
Thank you, sir.
Wavikar, sir.
Yes.
Thank you.
Thank you, sir.
Thank you for giving us your valuable time and guiding us on the provision of Consumer Protection Act, execution of decree, along with the landmark judgment of a national forum and state forum. It was a great pleasure having you amongst us. Thank you for giving us this opportunity. Bar Council of Maharashtra and Goa is so grateful to you. Thank you, sir. Friends, tomorrow we will have a session on different topic at the same time, that is 6 to 7 p.m. Kindly take a note of it. With this, I conclude this session. Thank you, Wavikar sir.